The subject matter raised by Mr. Kinyanjui relates to a file which is not before us here. And we have not taken any record in this particular file. But for the purposes of transparency, I will ask the parties who are expecting a judgment from us for their comment.
My lords, my ladies, I have the instructions from the team of the first petitioner, His Excellency Rigathi Gachagua, to make representations on his behalf. We have come here to pick the judgment in the petition before you. We have not received any order from the Court of Appeal stopping today's proceedings. We actually, as a matter of fact, not participating in that matter at the Court of Appeal, and therefore it will be very curious for us to have our legitimate expectations to get a judgment today interfere with a matter in which we are not participating. In the absence of a formal directive from a court higher than this, the Court of Appeal stopping this judgment, we ask you to deliver our judgment as scheduled today. That's all.
Thank you.
Of the 44th petitioners, my lord, I associate myself with the made by senior counsel. The fact that that file is not before you, my lord, form the basis upon which this judgment can be deferred. And most importantly, my lord, counsel having not given sufficient reasons, my lord, for adjournment, my lord, or arresting the judgment, my lord, I think the legitimate expectations of the 4th to the 49th petitioners, my lord, is that you render yourself as you set your mind and yourselves to do this afternoon, my lord. We are opposed to that application.
Thank you.
In the interest of time, I will speak for all my colleagues, for the respondents, and we associate ourselves with the submission of learned senior counsel, Mr. Ongoya. Yes.
Thank you.
My lord, on behalf of the third interested party, we associate ourselves with the submissions of the lawyers for the petitioner, first petitioner, and wish that, my lord, you could deliver judgment as it has been agreed before. I thank you, my lord.
Thank you.
Your Honor, on behalf of the second petitioner, we associate ourselves with the submissions of the other petitioners, and we say in the absence of a court order for stay, then we see no need of stopping judgment. That's all.
My lords and my ladyship, appearing for the 43rd petitioner, we also associate ourselves with the submissions of Senior Counsel Ongoya, and in the absence of a clear order and in respect of our legitimate expectations to deliver the judgment, we then oppose the application. Thank you.
Above that, perhaps it will benefit the court to notice that we have only but been served with the application. So in any event, even in the absence of the order, with the business of the day, Mr. at the Court of Appeal. Thank you.
Enjoy to address you as though it is a given. Ultimately grant his request, and therefore, as already submitted, there is no basis for that request he makes as we speak. Number two, if you were to grant his request, nothing would stop all the other petitioners in the cohort of petitions that were equally held in abeyance pending the delivery of this judgment. So there is nothing special about his petition that would require a different approach. Number two, rather number three, my lord, the record will show that throughout these proceedings, Mr. Kinyanjui has tried through one contrivance or another, through a letter of lamentation or another, to scuttle the process. This is just one of the series. It should be dealt the way the others have been dealt with. Thank you.
Mr. Kinyanjui, I'll give you a right of reply.
Thank you very much. There is no need for Learned Counsel to cast aspersions on me. At no time did I seek to stop these proceedings. Secondly, a voice has been raised there on the 29th of May last year. A year ago, your lordships and my lady made a ruling saying, and I quote, "This petition raises very weighty constitutional issues that are distinct from the consolidated petitions, by reason of which I'm answering that issue, that this is an impromptu, an afterthought, knee-jerk reaction." That's not so. That particular ruling of the 29th of May 2025 deconsolidated these E586 of 2024 from the consolidated petitions. That is a decision of the court, not my decision. Shouldn't the petitioner have abided by that decision? Yes, he did, and yes, he has. The 7th of May, everybody here was present when that decision was made to hear that petition. I'm answering, my lord, I'm answering because they say that this is something that I've just come up with to scuttle the hearing. It's my rejoinder, with tremendous respect, my lord, and I'm not going to take too long. I'm alive to the fact that this court is on a constitutional duty. My lord, the date for hearing was... I served that application from the Court of Appeal, deference to the Court of Appeal's directions. And we cannot sit here and pretend, as legal practitioners, we do not know the practice of the Court of Appeal. The Court of Appeal is seized of these proceedings. And this court is subordinate to the Court of Appeal. And I'm answering that issue as to no reason has been preferred to defer this judgment. The Court of Appeal being seized of those proceedings, which everybody here is fully aware. My friend has said, yes, he has been served. Everybody has been served. So we ought to give deference to that constitutional issue. The other issue raised is that, your lordship, there's nothing peculiar. There is nothing out of the ordinary from these consolidated petitions. Learned Counsel, really, having looked at my petition, never having answered in that petition, Mutomi Thiankolu never filed a single sheet of paper in that petition, and he's appearing for the 10th respondent. Your lordship, he cannot be heard to say that he has absolutely no reason to see what is peculiar. Your lordships, you saw the peculiarity of that petition. Your lordship, I'm not going to go. So that your lordship, the petitioner wants to be heard on merit because Article 25C says he should be heard and given that right to a fair trial. As I close, none of my learned friends here, when that petition comes up for hearing, should ever remove from their pocket the res judicata card. None of you, my Lord,